Do I not have it up here? It looks like I don't. Okay, sorry about that, guys. Let's start again. Talking about the judicial branch, this section. So, who are these 9 people looking at you? Yes, these are the Supreme Court members. Notice there's 9 justices. Chief Justice John Roberts is middle, the bottom row. Legal system settles disputes. That's the whole purpose. But how do courts decide cases? Courts will decide cases by hearing the facts on both sides of a dispute. Then they apply relevant law or principle to the facts. It's important to understand that courts have authority over the citizens, but they also have authority over the government. What do I mean by that? It means courts have authority over the other 2 branches of government. The courts can tell Congress, the legislative branch. Courts can tell the president, the executive branch, if their actions are constitutional or not. Courts are obliged to maintain neutrality, impartiality when deciding disputes. Neutrality, impartiality, there's no bias. The essence of the rule of law is that government officials are judged by the same laws as the citizens. This means that everybody in the United States, whether you're a private citizen or you're a public official, we are all treated equally. Court cases proceed under criminal law and civil law. We have these 2 broad categories of law, criminal law and civil law. Criminal law. This is the law branch that defines and provides punishment for criminal acts. It deals with cases in which the government charges an individual with violating a statute that has been enacted. A statute is a law, by the way. A statute that has been enacted to protect public health, safety, morals, the welfare of the citizens. But I want you to understand, in our legal system, whether it be criminal law, whether it be civil law, we operate under an adversarial system. What's an adversary? It's an opponent. It's a foe. It's that simple. We have 2 sides. The first side is the plaintiff, P-L-A-I-N-T-I-F-F. P-L-A-I-N-T-I-F-F. The plaintiff is the accuser. The other side, the defendant. The defendant is simply the one who is being accused. In criminal cases at the trial level, the government is always the plaintiff. They are always the party that brings a complaint to court. They are the ones that allege a criminal violation has been committed by the named defendant. Why is the government always the plaintiff? Why are they always the accuser in a criminal court? It is because the only one who has the authority to create laws is the government, is the legislative branch. We can be victims of crimes, we as individuals. We can be victims of crimes, we can be witnesses to crimes, but we do not have the authority to create our own laws and then force these laws on others. That is only the government. So the government is always the plaintiff in a criminal case. Punishment in a criminal case, punishment under criminal law. If a defendant is found guilty or pleads guilty, however you get there, punishment can be incarceration, punishment can be a fine. Now, civil law. Civil law or civil cases, these involve disputes among individuals, groups, corporations, other private entities. However, it can be between a private group and the government. The government can be a plaintiff in a civil suit. They can be a defendant in a civil suit. Can you sue the government? Yes. Can the government sue you? Yes. When deciding civil cases, we see that the courts, same thing, they'll apply statutes, laws, they will apply legal precedent. Precedent is what has happened in the past. They're going to look at past court cases to decide, for guidance. If you lose your court case, your punishment can be compensation. You are giving somebody money. Punishment can be you quit performing the action that is harming somebody. Now, I started talking about precedents just a second ago. This is going to apply to both civil and criminal court cases, civil and criminal law. I said that the courts, they will look at precedent. They will look at previous court cases. There is a term, a Latin term, stare, S-T-A-R-E, stare, S-T-A-R-E, decisis, D-E-C-I-S-I-S. Latin phrase meaning literally, let the decision stand. All that does is it ensures that there's not going to be any wild, strange court rulings. They're going to follow the footsteps of what came before them. We as individuals, we as citizens, we actually need this stare decisis. We need to have precedents so that we know if the court punishes us, that they're punishing us in a way that is equitable, in a way that is equal to those who have been punished before us. If we're punishing people and we're fining them $10,000 for whatever reason, and then, it happens 10 times, 20 times, 30 times, then the court comes to our case and says, we're fining you $500,000. Wait, what the heck? Everybody else has been fined $10,000 and suddenly you're fining me $500,000. Are we being treated equally under the law? No. So as individuals, we do need this precedent. Types of courts include trial, appellate, and supreme. The U.S. federal system has a three-tiered federal system. We have a three-tiered judiciary with various types of jurisdiction. And I'll explain jurisdiction in just a second. The bottom level, the lowest level of the judiciary is the trial court. This can also be referred to as the district court. Middle level is the appellate court. Appellate. Please say appellate a couple of times. People will refer to this as appellate. It's the appellate court. It could also be referred to as the circuit court, the court of appeals, but this is our mid-level court. Our highest level is going to be the Supreme Court or simply the court. If you are reading something and you see the court with C and the C is capitalized in court, this means the Supreme Court. Jurisdiction of the Supreme Court. This is where we start to get a little confusing. So bear with me, listen close. I am going to there are two possible definitions of jurisdiction. The first definition of jurisdiction is the area, the physical area the court has authority over. The second type, or the second definition of jurisdiction, is what they can do with the case, when they can hear a case. So if we're talking the first type, if we're talking a physical location, it would be something like a city court has jurisdiction. They have authority within city limits. County court, they have authority within their county. Supreme Court, their authority nationwide. It applies to everybody. Second type of jurisdiction I was just mentioning, that authority to hear a case. We see that Article 3, we say it creates the judiciary, but in all reality, it doesn't. Article 3 creates one court. It creates the Supreme Court. It provides some benefits and provides some protections that have been expanded to those other two levels, to the appellate level and the trial level. These are lifetime tenure. Once you become a Supreme Court justice, or once you become a federal judge, how long do you serve? Until you quit, until you die, or until you're impeached. That is lifetime tenure. You have the job as long as you want it, or until you do something illegal and Congress removes you. The second thing Article 3 does is it protects justices in their pay. It states Congress cannot cut the pay of a justice or a federal judge. This is important. We'll talk about this at the end of this lecture. Anyway, back to Article 3. Article 3 gives the Supreme Court this other type of jurisdiction, the second type of jurisdiction I'm referring to. This is going to be original jurisdiction and appellate jurisdiction. Original jurisdiction is the authority, it's the ability to hear a case for the first time. Facts are established, evidence is presented, a verdict is rendered. The Supreme Court has original jurisdiction in all cases involving foreign ambassadors, issues in which a state is one of the parties involved, this kind of thing. The other type of jurisdiction here, appellate jurisdiction. The Supreme Court has appellate jurisdiction in all federal cases and in all cases originating in state courts. We see that civil and criminal cases can be appealed in federal courts when they raise federal issues. Now, which type of jurisdiction, original or appellate, do you think that the Supreme Court exercises the most? It is appellate. There are not very many cases, I can't think of any lately, where the Supreme Court would have original jurisdiction. So understand it does happen, it does have it, but for the most part, they're going to exercise appellate jurisdiction. I told you that the judicial system is a three-tiered system: trial, appellate, and supreme. I followed that up by saying that Article 3 only creates the Supreme Court. Well, if that's the case, where do these trial courts come from? Where do these appellate courts come from? What have I told you before? When all else fails, Congress is the answer. Once again, Congress is the answer. Congress, under Article 1, they have the authority to create the lower federal courts. So they have the authority to create these trial courts, these appellate courts. But once these trial courts and these appellate courts are created, the protections in Article 3 that are extended to the Supreme Court are now extended to these lower courts. There is an exception. We have these specialty courts. Congress has the ability to create specialty courts. This is going to be things like the U.S. Court of International Trade, bankruptcy courts, immigration courts. These Article 1, these legislative courts, they are not as independent as Article 3 courts. They are not as independent as the federal courts because their judges are appointed for a fixed 15-year term. They do not have, the specialty court judges do not have a lifetime appointment. Federal court hears a small percent of all cases. The federal court, they have the authority, they have the power, they hear both civil and criminal cases. But if we're looking nationwide, they actually don't do very much. They're not very busy. Why is that? Simply because if you remember when we were talking about federalism, these two layers of government, if you recall, state government, well, they basically have the responsibility. They basically do the heavy lifting. They do the heavy governing. They have that police power, the power of coercion. They're creating their laws for the health, the safety, the morals of the citizens. So what happens is actually about 95% of all crime or all civil laws, these are tried at the state level. That means that only 5% left is tried at the federal, or only 5%, maybe tried at the state, but then there's a constitutional question, so it jumps to the federal level. But yeah, they don't hear much. But let's look at each one. Lower federal courts handle most cases. By this, we're talking about that trial court, that district court. There are 94 district courts spread throughout the United States. Each has jurisdiction over their entire district, but they have jurisdiction. They only have jurisdiction. They only have authority over their district, their location. So if the district judge from Court 7 makes a ruling, it only applies to Court 7, to District 7. It doesn't apply to District 14, to District 28, to District 35. You have a judge that's in charge. They're going to hear the case. The trial court, this district court, they have original jurisdiction. They are going to hear the case for the first time. Evidence is going to be presented, facts determined. A judge, there's one judge in charge, so a judge or a jury is going to render a verdict. Do trial courts have discretion? Do trial courts get to pick and choose which cases they hear? No, they don't. Any case, any trial case that is assigned to a trial court, to a district court, the court must hear. This is why they're handling most of the cases. The court is required to hear every case in front of it. Now, just because a case goes to trial doesn't mean it's going to go through the entire process. Doesn't mean we're going to end up with a verdict at the end. In civil cases, what may happen is the two parties may agree to a mediation. They may go to an unbiased third party. They agreed to abide by his ruling, to follow his ruling. They'll present the facts. The unbiased third party, the mediator, will make a decision. Both sides accept it. They will then withdraw their case from the district court. Why would two parties, why would these two, the plaintiff and the defendant, agree to do this? Court is expensive. Lawyers charge a lot of money. If you do this mediation, it saves time, it saves money. You may not win, but you probably won't lose either. Now, if we're talking criminal law, what we have in criminal law is something called plea bargains. It's this negotiating session, I'll get out in a second, negotiating session between the prosecuting attorney, the government attorney, and the defense attorney. It might be, well, if you, the defendant, plead guilty today, we'll reduce the charge. We'll reduce it to a certain level, or we may even change it, period. We may change the charge from driving while intoxicated to reckless driving. A plea bargain might be, well, if you plead guilty, you could serve up to 180 days in jail. You'll serve 3, and that'll be it. It'll be over. You'll go home. So we do see plea bargains happen quite often in criminal court. These are good for everybody. It's good for the court, saves court time, saves court money. These are good for the parties, the plaintiff or the defendant, saves them money, saves time. Appellate courts, this mid-level court. I said that the trial court, the district court, has original jurisdiction. The appellate court, they have appellate jurisdiction. No original, only appellate. Their only job is to review the decisions of the trial court, this district court, and to make sure proper procedure was followed. No original jurisdiction. There's not going to be any new evidence presented, no new facts found, just was procedure followed. There are 13 federal courts of appeals. They are spread throughout the United States. Each one has authority, jurisdiction over a certain area. Texas. We are located in the 5th Circuit. The 5th Circuit is headquartered in New Orleans. The 5th Circuit has jurisdiction over Texas, Louisiana, and Mississippi. The appellate courts are a little different in that they do get to cherry pick. They do get to decide what cases that they're going to hear that are appealed to them. This means that, honestly, the appellate court, they only hear 15, maybe 20% of all cases that are appealed to them from the trial level. They don't have to take it. That area of jurisdiction. This is like the district court. I told you the district court of District Court Judge 7, the judge for District Court 7, makes a decision and it only applies to that district. The same is true for the appellate courts. If the circuit court, the Court of Appeals, the 5th District, when they make a decision, this decision only applies to Texas, Louisiana, Mississippi. So you can't apply it to Washington, D.C., Washington State, Maryland, California. It is only going to apply to these three states. Is this a problem? Just a little bit, because you can have each district interpret something differently, so you can actually have different laws throughout the United States. When you go to the appellate court, you're actually making your argument in front of a 3-judge panel. They're going to be more interactive. They're going to ask you questions. They're going to ask for clarification. They will actually talk to the attorneys. At the trial level, the judge does not do that. Supreme Court is the court of final appeal. Okay, understand, at the trial level, if you lose, in a civil case, if you lose, you can appeal to the appellate court. At the trial level in a criminal case, if the defendant loses, you can appeal. If the prosecuting attorney, the state agency loses, they cannot appeal. That's double jeopardy. That's something we'll talk about in the next chapter. But they appeal up to the appellate court. If you lose at the appellate court, you can appeal again to the Supreme Court. The Supreme Court is the court of final appeal. How does this work? I'm going to give just to hop from one to the other, a quick overview. Really, really quick. I'll get into more detail. Each appellate court has what we call a circuit court justice. This means that one Supreme Court justice is assigned to each district. So some justices, 9 justices, 13 districts. 9 justices have more than one district. If a case is going to be appealed from the appellate court to the Supreme Court, they will look at it first. I will go into detail about that in a few minutes. Please hang with me. Let's talk about the actual Supreme Court now. The Supreme Court is the United States' highest court. The court is made up of a Chief Justice and 8 associate justices. Does the Supreme Court does the Chief Justice have any power? Do they have any superpower, or are they special? Yes and no. Mostly no. It is no in the fact that when they make a decision, each justice has one vote. Theirs doesn't count any more or any less than any others. They don't get any special treatment. It is yes because the Chief Justice is a historical footnote. And what I'm talking about here is that as we're looking back over our history, when we're talking about Supreme Courts that decided significant cases, Roe v. Wade, Brown versus Board of Education, Plessy v. Ferguson, in 20, 30 years, Oberfeld versus Hodges is going to fall in here. Which court decided? And this is that historical footnote. All we're going to say is this court decided. It is the court is decided, the court is known by the Chief Justice's last name. So for this court and their decisions, it's going to be known as the Roberts Court made this decision. Could be the Warren Court in the past, the Rehnquist Court, the Berger Court. That is the only thing special about the Chief Justice. Now, there's 9 justices. Why? What's special about 9? Honestly, what? It's a multiple of 3? Yeah. And again, so it's 6, 12, 15, 18, 21. So it's odd. Yeah, that helps. But what is it? What makes 9 special? The answer, absolutely nothing. Then why do we have 9 Supreme Court justices? simply because at this time and date, Congress has decided that the appropriate number is 9. What if Congress decides to expand the numbers of the Supreme Court justices? Can they do this? Yeah, they can. Could they subtract? Could they lower the number of Supreme Court justices? Yeah, they could do that too if they so chose. So right now, the number is set to 9 simply because Congress says so. There's nothing special. As long as we can keep an odd number up on the court so that we don't have a tie, Congress can adjust the number up. They can adjust the number down at their whim. The question I'm usually asked at this point is, how do you become a federal judge? Or how do you become a justice on the Supreme Court? Easy. These federal judges, these federal justices are appointed by the president, but they have to be approved by the Senate. Nominees, these selections, they're generally people that are among the more politically active members of the legal profession. Often before the president makes a formal nomination, we will see something called senatorial courtesy. Senatorial courtesy is simply the practice where the president, before formally nominating a person for federal judgeships, seeks an indication that senators from the candidate's own state will support this nomination. We as the president, we may ask the senator from the home state, say, hey, we've got an empty judicial bench. We're thinking about nominating so-and-so. What do you think? We'd like to nominate one of these 3 people. Who do you think's the best? Or they might even say, Senator, we've got this empty seat. Why don't you give us a list of people you think would make a good judge or a good justice? Why are we going to get the senator involved? Where are we going to extend the senatorial courtesy? Well, remember, those judges are appointed by the president, but they have to be approved by the Senate. What happens if the president appoints somebody that the home state senators dislike? They don't agree with for whatever reason. Do you think they're going to support this nominee? No, they're not going to support him. And they're going to tell all their Senate friends, hey, this person's going to make a horrible judge. Don't support him. Don't vote to confirm him. The president doesn't get his pick. The president appears weak. Do presidents like appearing weak? No. So we want to kind of load the deck. We want to stack the deck before we go in. That's why we're going to at least get that home senator to approve. Solicitor General. The Solicitor General is the top government lawyer in all cases before the Supreme Court when the government's a party. So when the U.S. government's a party, when they are part of the case, they're the plaintiff or the defendant, the Solicitor General is involved. But remember, do we, the United States government, the federal government, have to be a party? No, they don't have to be involved at all. What about when they're not involved? What does the Solicitor General do? Does he just sit there, he or she sit there and twiddle their thumbs? No, actually, the Solicitor General, the U.S. government, you, me, anybody, we can actually get involved in a court case indirectly. We can get involved in a court case even if we are not a party, if we are not the plaintiff, we're not the defendant. We do this by filing an Amicus, A-M-I-C-U-S, Amicus, A-M-I-C-U-S, Cariah, C-U-R-I-A-E. C-U-R-I-A-E, an Amicus Cariah brief. I will now just refer to this as an amicus brief from here on out. Another Latin phrase means friend of the court. Any individual or group who are not parties to a lawsuit may file an amicus brief. We are seeking to assist the court in reaching a decision by presenting additional briefs, by presenting additional information. Now, what these briefs are doing, they're presenting our perspective. We're going to do legal research. And we're going to say, based on these previous court cases, based on precedent, Supreme Court, this is how you should rule. And I'm torn here when it comes to an amicus brief. Does the Supreme Court justice like to receive an amicus brief? On one hand, I'm sitting here thinking, my attitude would be, I am on the top court of the land. My decision affects who? Everybody in the United States. I am one of the 9 top dogs. Who are you to tell me what I should do? But then on the other hand, I sit here and think, if I get an amicus brief, you have actually already done a lot of research for me. You have made my job easier. Yes, you're telling me what I should do, but you're showing me facts to back it up. So as a justice, do I like amicus briefs? I'm not sure. What do you think? How would you react to receiving one? The power of the Supreme Court is the power of judicial review. One of the most important powers of the Supreme Court is something called judicial review, not to be confused with appellate jurisdiction, appellate review, judicial review. This is the power of the court to examine and, if necessary, invalidate or declare unconstitutional actions that were undertaken by the legislative and or the executive branches. Judicial review allows the courts to review acts of Congress. Where do we find judicial review in the Constitution? Article 1, Article 2, Article 3, where? The truth is, nowhere. Judicial review is found nowhere in the Constitution. Judicial review was this concept or this power that was kind of taken/given. The Supreme Court took it because the executive branch, the presidency, offered it to them. Back in the early 1800s, we had a court case called Marbury versus Madison. President Adams is going out of office. President Jefferson is going to be inaugurated the next day. So President Adams, he's trying to fill commissions. He's trying to appoint these low-level governmental officials or people to government positions just because he doesn't want President Jefferson to be able to put his people in there. So he's appointing people to these positions. He's giving them commissions. The people in Washington, D.C., their commissions are delivered that night. The people outside of Washington, D.C., their commissions are put aside to be delivered at a later date. Adams goes to bed thinking, as president, I have done what I'm supposed to do. I have filled these positions. Jefferson gets sworn in the next day, and one of the first things he does is he sees these commissions that have been signed, but they have not been delivered. So Jefferson says, since these commissions were not delivered, they are null and void. They are no good. Adams' commissions aren't worth the parchment they're written on. So he starts filling these positions. He starts making his own appointments and just kind of saying, I'm sorry, President Adams, you're the people that you picked, they're not going to get the job. Well, Mr. Marbury was one of President Adams' picks that the commission was set aside. It was not delivered, but he really wants this job. So he sues President Jefferson over this commission, saying it was done by President Adams. It should be legal. I should have this job. He sues the executive branch. The name Marbury versus Madison is Madison, who would also later become a president. Madison is the Secretary of State for Jefferson at this point. So it is his department, the State Department, that's arguing this case. Marbury sues in the Supreme Court. Supreme Court says, we'll take it. Jefferson, the executive branch, actually asked the Supreme Court to take it. They say, rule on this, we will abide by your ruling. What does that mean? Rule on this, we give you permission to rule on this issue regarding executive power, and we will abide by it. They gave this power to the Supreme Court. So the Supreme Court says, hey, not a problem. We'll take it. And they do. And this is where we see judicial review. Now, it is an accepted practice. The executive branch knows the courts can do it. The legislative branch knows the courts can do it. The courts know the court can do it. Does that mean they do it very often? No, actually they don't. Ever since the early 1800s, we've only seen the courts use judicial review maybe 165, 170 times to strike down congressional acts. Now, there's this question, why do we have judicial review? If the framers wanted the courts to have the powers of judicial review, since it's not in the Constitution, why didn't they put it there? And this is a valid question. The answer tends to be what we believe is, if you think back, or if you have siblings, how do young people, how do kids learn things? They learn by mimicking. They learn by imitation. When we were a colony, if we look over at Great Britain, we have a king, we have a House of Lords, we have a parliament. Basically, the king would be the equivalent of the president. The president doesn't have quite as many powers, but we could associate these two together. And the House of Lords we could associate with Congress. So far, so good. Well, if you were in Britain, if you wanted to create a new territory, if you wanted to open a new business, if you wanted to start a new business, you had to get permission from the Crown. You had to get a charter from the British government. Now, in the House of Lords, there's a small committee that reviews every charter request. That is their job. They're going to review all these bylaws, all this written laws that I'm going to put into effect once my charter is granted. This committee, this small number, are reviewing these charter bylaws for acts of repugnancy. Acts of repugnancy, these are acts that go against the Crown. These are acts that go against British law. Well, I mean, now let's think about this. If we're talking, we learn from imitation, we learn from mimicking. President, kind of like the king. The executive branch, kind of like the House of Lords. This small number of the House of Lords that reviews laws to make sure they don't go against British law, doesn't that kind of sound like the Supreme Court and judicial review? That they're reviewing presidential acts, executive acts, there we go, congressional acts to make sure that they're not unconstitutional, to make sure that they abide by the Constitution, to make sure they're legal. So we tend to think that the framers intended the judicial branch to have judicial review because this is what we were used to. For lack of a better term, this is what we as colonies had grown up with. This is what we knew. Judicial review also applies to actions by the state. The Constitution does not explicitly grant the court the power of judicial review at the national level, so why would it be applied to the state level? The logic of the Supremacy Clause, Article 6, is very strong. It states that laws passed by the national government, treaties, any treaties entered into by the federal government, these are the supreme laws of the land. They're superior to all laws adopted by any state or any subdivision. Also, we see something called the Judiciary Act of 1789. This gave the Supreme Court the power to reverse state laws and constitutions whenever they conflict with the U.S. Constitution. So we actually see two actions, two items, which tell the federal government, which tell the Supreme Court, you can overrule state-level courts. What are decisions based on? Well, many of the court's decisions are based upon statute application. This is just simply what the justices interpret the law to mean. However, over time, judges have developed a body of principles called common law. Common law is simply based on the precedent set by previous cases. Most cases reach the Supreme Court by appeal. We talked earlier, Supreme Court has original jurisdiction, Supreme Court has appellate jurisdiction. They don't use much original jurisdiction. Most of their cases come by appellate jurisdiction. But how does it get there? I'm going to talk about writs for a second, certain type of writ. If you recall, and I hope you understand, the appeals process, you're going from a lower court to a higher court. So you're going from the trial court or the district court to the appellate court, the circuit court, the court of appeals. If you appeal to the Supreme Court, what's going to occur? That circuit court justice that's assigned to the appellate court, they're going to look at the appeal. They're going to see, does it have any grand constitutional questions? If they say, nope, no constitutional questions, no mistakes, they wad up your appeal, crumple it up, throw it away. That's the end of your appeal process. But if the circuit court justice says, you know what, this is a legitimate question, they raise an interesting constitutional point, the Supreme Court may need to consider this. He or she, will then bring this question, they will bring this case in front of all 9 justices. The 9 justices will discuss this case. They will vote. We are looking for a vote of 4 or more. This is called the rule of 4. If 4 or more justices agree to hear this case, congratulations. Your case has made it to the Supreme Court. If 3 justices or less vote for it, sorry, it's going in the trash can. You didn't do anything. So you have the rule of 4. At least 4 justices must agree to hear this case. Once 4 or more justices agree to hear this case, the Supreme Court will issue a Writ of Certiorari. 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 Once again, Latin phrase. It just means to make more certain. All this is doing is the Supreme Court is issuing this writ of certiorari to whichever appellate court heard the case. They are directing that particular appellate court to send all the information, to send everything they have to the Supreme Court so they can hear the case. Does the Supreme Court have to hear every case? No, they don't. They get to be even more picky. They get to be more choosy than the appellate court. I told you the appellate court hears maybe 15, 20% of all cases appealed to it. The Supreme Court is going to hear less than 1% of all cases. With this in mind, we see a lot of groups that are lobbying for access. They are trying, interest groups, society forces, will use several strategies to persuade justices to listen to their problems. Group lawyers will plan carefully to bring a case into court. They're looking to pick the right client, the right case, the right time, the right district, the right jurisdiction. They want their case to have a certain publicity level so that they will be successful in their efforts to bring the issue to the court's attention. Why do you have to plan this out? Think about this. In 2015, the Supreme Court ruled same-sex marriage was legal throughout the United States. So let's go back before 2015. Let's go to 2010, where some states it's legal, most states it's not. Why are you trying to get to the Supreme Court? Because the Supreme Court, their decision affects all 50 states. Their decision affects everybody. So you want to get to the Supreme Court, and you want the Supreme Court to rule in your favor. 2010, you're starting this journey to the Supreme Court in regards to same-sex marriage. Do you file your case in California, or do you file your case in Texas? Now, most of you are saying you file your case in California. No, that is incorrect, I'm sorry to say. You file your case in Texas. Why? Well, California's more progressive than Texas. They're going to rule for you. Why wouldn't I file it in California? That is exactly why you don't file it in California. You're going to win. Remember, you can only appeal if you lose. If you win at a district court in California, that court decision's only valid in that district in California. But you come to Texas and you lose. You appeal. You appeal to the Fifth Circuit. You go argue in New Orleans. And you lose here. It's okay. Then this is where you appeal to the Supreme Court. This gets you there so they can make a decision that's going to affect everybody nationwide. Your strategy, you are playing, it's a 3-round game, and you are playing the first 2 rounds to lose. The path to the Supreme Court is long. Congratulations. Your appeal made it. You got through the rule of 4. Court says, we'll hear your case. Do they tell you today and say, come argue it in a week? No, it's actually a very lengthy process from start to finish. Once the court tells you that it has accepted your case, attorneys on both sides, the plaintiff and the defendant, will prepare the briefs. Briefs are just written documents in which attorneys explain, using case precedent, why the court should find in favor of their client. Who else is going to get involved here? A few minutes ago, I talked about amicus briefs. Who can file an amicus brief? Anybody. So at this point, while the judges are reviewing the briefs, they will look at the briefs from the attorney or from the plaintiff. They will review, that's the word I was looking for. They will review the brief by the defendant. Then they will also review any amicus briefs that are filed with the court just from these interested parties. Once the briefs are over, they've been read, they've been reviewed, we go to oral arguments. Oral arguments occur under a strict time limit. Attorneys for both sides appear before the court. They present their position. They interact with the judges. They will answer any questions that are posed by the justices. And they'll not ask questions. They might ask for clarification. It is a very strict and very short time limit. It might be the prosecutor or the plaintiff's attorney might get 2 hours to present their case. The defendant, the defense attorney, they have 2 hours to present their case. After these are done, these arguments are presented, the plaintiff's attorney has a short time for rebuttal, R-E-B-U-T-T-A-L, rebut to dispute, to refute what the defense attorney said. After that, the defense attorney has an even shorter time to address the points that plaintiff's attorney just made. Guys, that is it. That is oral arguments. These cases aren't going to last any longer than a day. Well, once oral arguments are over, then what happens? We see that the judges will do what we call conferencing. After the arguments, conferencing, the justices meet to discuss the case. They will talk this discussion. It is kept secret. They will sit here and discuss who made the better legal argument and why. Do you think that judges or that these justices will try to persuade other justices to their way of thinking? Sure, they do, all the time. The conference period lasts until we get a majority decision. Majority decision says, okay, so-and-so won, so-and-so lost. Now, once we get this decision, once they make their decision, they pick their winner and loser, we have an opinion writing. This is going to be the official decision. Somebody from the majority team is picked to write the decision. Or it's picked to write the opinion. The opinion is simply the written explanation of the Supreme Court's decisions in a particular case. These written opinions are very important because they set precedent for future cases. This is what all the lower courts are going to have to refer to in the future. So these decisions have to be well written. Once a majority opinion is drafted, it is circulated to the other justices who agreed on the majority side. Now, how many majority opinions can there be per court case? I'm going to repeat this. How many majority opinions can there be per court case? The answer is 1. Now, understand, yes, the the numbers on the majority side can vary. 5-4, 6-3, 7-2, 8-1, 9-0. But per case, only one of those numbers is going to be in effect. Only one majority decision. This case was either decided 7-2. It was decided 6-3. It was not decided both ways. So one majority opinion. Now, with this in mind, we do see other types of opinions. We have this majority opinion. This gives us the winner. This gives us the loser. This spells out the court's rationale, the court's logic. Now, in a majority opinion, only one, but we can have something called a concurring opinion. Concurring, concurring opinion. And a concurring opinion, one judge or two judges might say, yes, I agree with the majority. The plaintiff won, they are right, but I agree for a different legal reasoning. I reached my decision by some other legal wrangling. I agree with the decision. I disagree with the process of how they got there. Now, this other type of decision, so majority, concurring, this last type of decision is called a dissenting opinion. dissenting, dissenting opinion. This is going to be written by a judge on the minority side, or however many dissenting opinions, there can be multiple. And all they're saying is that the majority is wrong. They just totally missed it. They messed up. They should not have decided this way. So please remember, there can be multiple concurring opinions, multiple dissenting opinions, but there can only be one majority opinion. What can influence decisions? You know, most of the things we look at, the Supreme Court explains its decisions in terms of law, in terms of precedent. However, there's a couple of other things that we are going to take into consideration. We individuals, these political scientists, we love to sit here and watch the court. We love to try to predict how a court is going to rule. And there are certain things we look at. The first thing we're going to look at is something called judicial philosophy. What judicial philosophy does the court practice? Two different types. The first type of judicial philosophy, judicial restraint. Judicial restraint, adherents to this judicial philosophy, people who follow judicial restraint, they refuse to go beyond the clear words of the Constitution. They are attempting to interpret exactly what the framers meant, and they will not go any further than that. This is what the framers meant. This is what the framers wanted. Yes or no. Now, the other type of judicial philosophy, judicial activism. Judicial activism, these people who are judicial activists, or this judicial philosophy, claims the court should go beyond the words of the Constitution. They should go beyond the words of the law. They should go beyond the words of the statute. And they need to consider the broader societal implications of their decisions. Yes, this is what the framers want, but how does this affect society? So we know if a judge practices judicial restraint or judicial activism. This is half of what we need to know to make our guess, to make our prediction. The other is a judge's political ideology. Now, remember, judges, they're supposed to remain neutral, impartial. So how do we know a judge's political ideology? Honestly, we don't. We assume that we know it. How do we do this? We look at the president who appointed him. What I mean by that is if we have a liberal, if we have a Democratic president appointing a justice, is he going to appoint a justice that has a liberal, a Democratic ideology, or is he going to appoint a conservative justice? No, he's going to appoint a liberal Democrat to the bench because he wants this justice to rule in favor. He wants this justice to agree with what the president's doing. And it's the same thing with a conservative judge. They're going to appoint who they perceive to be conservative in their political ideology, a conservative president. They're going to appoint who they seem to be a political ideology, a conservative, to a judge, to a justice, because they want them to agree with their presidential administration later on. So we don't know what the judge's political ideology is, but we assume that it is the same as the president who appoints them. So we know their judicial philosophy. We know their political ideology. Now, can we accurately predict how this justice is going to rule? The answer is no. It is still very unpredictable. How come? Go back, beginning of this chapter, beginning of this lesson. I said, I'm going to tell y'all these protections by Article 3. Lifetime tenure, can't cut pay. They're very important for the end of the lecture. End of the lecture's here. Let's talk about why they're important. With the power of judicial review, the power to review acts by the president, the power to review acts by Congress, the judicial branch actually has to have true independence. They cannot be beholden to them for anything. Imagine what would happen if the judicial branch told Congress, okay, well, using our power of judicial review, we're going to find this act unconstitutional. And Congress had the authority to say, okay, you're fired. Or, okay, find it unconstitutional. We're cutting your pay by 50%. What would the judicial branch do? And I bet you they would find nothing unconstitutional. Equate this to your boss coming into you and saying, I've got this wonderful idea. He or she tells you about the idea. Then they ask that dreaded question. What do you think? And honestly, you think it's the worst idea you've ever had. But what do we tell our boss? Oh, it's wonderful. It's great. It's going to work. No, we know it's not. Why do we lie? We may not like our job, but we want to keep our job. We like making money. What would happen if Congress or if the president had the power to fire judges, had the power to cut their pay? The court, would not be an independent branch, so we would not see them do the job or be able to do the job that they were given. Thanks, guys.